Good evening and welcome to Current Affairs. So, there is a complete confusion as far as the largest democracy in the world is concerned. So, in India, we are observing what are the developments that are taking place. Yesterday, we have seen Uttarakhand High Court has quashed the president's rule and it has reinstated the government in Uttarakhand. And we were discussing yesterday that the central government may move the Supreme Court. And the central government has approached the Supreme Court of India, and the Supreme Court of India has imposed stay order on the order that is given by Uttarakhand High Court, meaning in Uttarakhand, the president's rule will continue. So, what is happening here? So, meaning we are talking about an article called 356, which is permitting the President of India to declare President's rule in a particular state. So, whether it is valid or invalid, on what conditions, what are the grounds that you can impose? So, we have the Constitution since the year 1950, but even today also the confusion is still going on. I was telling you so many times that Article 356 is the most misused article of this constitution. Though Dr. B.R. Ambedkar made it very, very clear that it should remain as a dead letter, it was not a dead letter since the beginning. It has been being imposed by various parties which are there in the government. So today it is a BJP government. When Congress party was there in the power, even then it was misused. So now it is becoming like a tool to take the revenge on some other political parties which are there in the power in some other state. So this is a very, very unfortunate situation that is happening. We have discussed all the points. Number one, in Uttarakhand, President's rule has been declared. The reason, so we know this. Immediately, the Chief Minister has moved the High Court, and yesterday, the High Court has given the verdict, quashing the order of the President, and the High Court has reinstated the government in Uttarakhand. And it has asked them to go for the floor test on April 29th. But today, the Honorable Supreme Court of India issued a stay on the order that is issued by Uttarakhand High Court, meaning in Uttarakhand, the president's rule will continue. Today, what happened? The development today. The Chief Minister Harish Rawat, he organized cabinet meeting today. It seems that he cleared 11 proposals that are pending with the government. He cleared it. And all of a sudden, just now, the Supreme Court made it very, very clear the president's rule will continue. And the Supreme Court has posted this particular case for April 27th. So meaning today is April 22nd. So we have to wait up to April 27th for the decision to be given by the so-called Honorable Supreme Court. What is this? Why there is a confusion regarding this particular article? There is no clarity. There is no clarity on this. That is the reason why in any state, whenever the president's rule is imposed, the first case or the judgment that is given by Honorable Supreme Court will come to our mind. That is the 1994 SR Bommai case. So what exactly is this? So in that particular case, the Honorable Supreme Court has given certain directions when this president's rule has to be implemented. And during that particular judgment, it made it very, very clear. I'll tell you the story after some time. During that particular judgment, the Honorable Supreme Court made it very, very clear that without giving permission to the existing government to prove the majority, to give a chance to prove the majority on the floor, you cannot dismiss the state government. So meaning there are certain procedures that are expected to be followed. And these procedures have been given by the Supreme Court of India in the year 1994, and it is very famously called SR Bommai versus Union of India case. So since that particular time, the amount or the intensity of the declaration of the president's rule has come down. But unfortunately, in the recent past, we have experienced Arunachal Pradesh and we are experiencing Uttarakhand. That's the reason why long discussions and debates are going on this. So this is the time has cropped up. So many people were thinking in the year 1994 saying that because the Supreme Court has given certain directions, maybe the government of the day will follow that. No. So this is the glaring example of today that the governments are violating those principles. And based on that, the Uttarakhand High Court has quashed the order of the so-called the president. And today, the Supreme Court has given stay order on the order that is issued by the High Court. So only one thing what we need to do is that we need to wait up to April 27th till the next hearing, and on that particular day, what is the apex court is going to say, we have to wait and watch. But my dear close friends, this is the time in India. See here, some people will argue that the order of the president cannot be subjected to judicial review. Why it is not subjected to judicial review? After all, who is the president of India? President of India is the first citizen of the nation, there is no doubt, and he is enjoying a great status, respect, and honor in the nation. But we should not forget that India is a country where we are following the principles of the parliamentary form of government. In parliamentary form of government, the Council of Ministers headed by the Prime Minister is the real executive. And this Prime Minister, who is heading the Council of Ministers, will be giving the advice to the President of India, and that President is expected to act on such advice. That is the reason why we are not finding any fault with the President of India, but we are finding fault with the advice that is given by this group, which is headed by the Prime Minister. You should not forget certain things. In a parliamentary democracy, in a democratic system, the people will elect their own representatives. Any party which gets the majority will form the government, and that government is expected to continue for a period of time, as it is mentioned in the Constitution. Until and unless there is a constitutional machinery failure, you cannot dismiss the government. Though the Constitution has given the powers to the central government for the imposition of the president's rule, it is a responsibility of the government also to see that in a state, the democratically elected government to continue till the completion of the 5 years. Unfortunately, that is not happening. That is the reason why Article 356 is considered to be a draconian article. So this is really removing the government, which is present at the state level. What are the reasons? Reasons should be known only to the central government. Constitution is permitting for the imposition of the president's rule under very difficult and uncomfortable circumstances. But what happened in Arunachal Pradesh? What happened in Uttarakhand? The government needs to give the explanation. That's the reason why High Court of Uttarakhand has quashed the order, quashed the president's rule. But today, Apex Court again stayed the order of the High Court, and the president's rule will continue in Uttarakhand. That is the reason why in the beginning itself I said it's really a confusion. So when there is no clarity at the parliament level, when there is no clarity at the legislature level, when there is no clarity at the executive level, when there is no clarity at the judiciary level, how come there is a clarity for a common man in India? Obviously, the common man is really confused. What to speak on this? So common man will question, is there any value for me, for my vote in a democracy? How come you can remove the government? And some court says it's wrong, and some other court suspends the order that is given by the lower court. For how long we need to watch this show? If it is allowed to continue, then what will happen? Is it not a mockery on the democracy? That's the reason why this is the time that there is a need to think very seriously about Article 356. whether the decision taken by the President of India is subjected to judicial review or not. That is very, very important. That is the reason why I am going to show you some articles. I'll show you the articles now, but let me tell you, President of India is the first citizen of the nation. Lot of respect and honor is given to him. There is no doubt about this. He cannot be questioned by any court of law. That's the reason why he cannot be arrested even in the criminal cases. With respect to the civil cases, he may be asked to appear before the court only after giving him a prior notice of 2 months. Article 361 is giving enough protection to the governor and also to the President of India. There is no doubt. That's the reason why we don't call him to the court. Number one. Number two, that is Article 361. I'll show you after some time. Second one is the Article 74, Clause 1. Let me talk about this. Article 74, Clause 1 talks like this. There shall be a council of ministers headed by the Prime Minister to aid and advise the President. So like this, the article will continue. So finally, the meaning of this Article 74, Clause 1 is that there shall be compulsorily a council of ministers which is headed by the Prime Minister of India, and their main responsibility is to aid and advise the President of India. Since India is a parliamentary democracy, the President of India cannot take any decision and he has to act on the advice that is given by the cabinet headed by the Prime Minister of India. This is what is happening in India since 1950, since the times of the commencement of the Constitution. Now, if you question whether the decision of the President can be subjected to judicial review, it is not the decision actually taken by the President of India, but it is a decision that is taken in the cabinet which is headed by the Prime Minister. And some people will argue that in most of the President's rules, we have seen, President has declared the President's rule on the recommendation of the governors. Governor will send a report and he will mention that there is a failure of the constitutional machinery at the state level. Then the President will be declaring, of course, on the advice of the cabinet headed by the Prime Minister. Even in the Uttarakhand also, I think you remember, the Prime Minister of India was there in Assam and he was campaigning there. And all of a sudden he came to Delhi and he chaired the cabinet meeting. Immediately they have recommended to the President of India for the declaration of the President's rule. Some people will argue, I want you to understand all the points, my dear friends. Some people will argue that whether the President's rule can be declared even without the report of the governors. That is being questioned. And Constitution is giving the permission to do so. I'll show you the article now. Either based on the report of the governor or otherwise. Otherwise, in the sense, even without the report of the governor also, the President's rule can be. So we are talking about the concept of the republic. We are talking about the parliamentary democracy. We are talking about the sovereignty at the state level and also at the central level. We are also talking about the powers of the parliament. We are also talking about the powers of the President of India. So, at the same time, whether the judiciary is permitted to intervene or not. That's it. So these are the various issues we are talking about. I'm clear. That's the reason why if you are watching any news channel, TV channel, just don't get carried away by the statements that are given by some politician. Politicians will speak in favor of a particular party to which they belong to, but we are not politicians. And we are the people who are working for the democracy, and we are here for strengthening our democratic system. That's the reason why understanding the principles that are enshrined in the constitution is very, very important to strengthen our democratic systems. That is the reason why you need to read the constitution, understand the constitution, take the contemporary issues, match them, validate them, then you can come to a conclusion. Is it okay? Look at this. Our even in our highest judiciary also there is a confusion now. With respect to this, first I'll show you the document, then I'll talk to you with respect to the SR Bommai case. I want to show you some articles now, only for your understanding, okay? And you can use these articles while you write the examination. Article 356, provisions in case of a failure of a constitutional machinery in the state. Failure of the constitutional machinery in the state. Look at this. If the president, on receipt of a report from the governor of the state, if the president on the receipt of the report from the governor of the state or otherwise, look at the word very carefully, meaning president need not depend on the report of the governor every time. Even without the report also, the president is permitted to declare. If satisfied that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of this constitution, the president may be proclamation. The president may proclaim. Okay. What is the meaning of this? So this particular article is making it very, very clear. The satisfaction of the president is very, very important, that there is a failure of the constitutional machinery at the state level. But the point is that since the president of India is a nominal head, how does his satisfaction will come to the picture in reality? In practice, it is not the satisfaction of the president of India, it is a satisfaction of the cabinet headed by the prime minister. This is what is happening since beginning. Clear? That is the point number one. If there is really a constitutional crisis or breakdown of the constitutional machinery, then if the government recommends for the president's rule, it's fine. But what will happen if there is any malified intention of dislodging the existing government? Then what happens? Now think for a while. If there is really a constitutional machinery failure, there is no problem. You can declare the so-called the president's rule. And the president's rule is coming because of the advice given by the cabinet. And the cabinet has to take some material into consideration. I mean, the reasons must be taken. That is the reason why you cannot claim that what is the advice given by the cabinet to the president of India, that you need not question. That you need not question. Listen carefully, that you need not question. But we are questioning that on what material, on what basis you have given the advice. That is very, very important. That's the reason why the judiciary will look into the procedures also. Am I clear? Getting it very, very important. If some people are arguing that the cabinet has given some advice and the president has followed that, it's okay, fine. But based on what you have given the advice? That is called the material. What is the material? And the judiciary yesterday said very clearly, if there is any strength in that material, you have to produce that material before the court. On the name of the confidentiality, you cannot escape. That's the reason why the court said that judicial review is very much permitted. Okay. See here, kindly see here, you're all preparing for the so-called IAS examination. It is not just what is Article 356, 74, 361. No, it's not. That's not enough. So you should be in a position to link all these areas. That's the reason why some people will say polity easy. No, it's not easy. Take it for granted, please. You need to have lots of analysis to understand what is happening in the judiciary today. Take it for granted. My words. In some examinations, some questions are coming like this: the term of the President of India, at what age the Supreme Court judge will retire. So these are the simple questions that are being asked in those examinations because the examination standard is such. We are not commenting on that. But when it comes to the highest service you are aspiring for in India, you need to look into all these issues, and you should be able to interlink all these articles. Then only your answer will be acceptable answer. Then only you will get the good marks. Am I clear? Very, 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 very important. Is Article 356 not present in the Constitution since beginning? Since day one, it was there in the Constitution. But even today also there is a confusion. Why? It is such. The application of Article 356 is such. The implications are such. That's the reason why judiciary is also not in a position to give a clear-cut directions on this. Hope you are getting me. That's the reason why small questions in examinations, don't go by that. You have to be highly analytical. For that reason, you need to have thorough understanding of the Constitution. That's the reason why I always mention anybody who wants to become an administrator, a government servant, you have to be very, 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 very thorough with the Constitution of India. Superficial knowledge will not give the service, topmost service. Am I clear? Right. Now, this Uttarakhand incident is giving me an opportunity to talk to you about the importance of the Constitution also. That's the reason why kindly don't neglect. Next, I am going to the next statement. So during this time, the president may himself assume the functions, or he may ask the governor to assume the functions, or he may appoint anybody to assume the functions. Is that okay? And the president also can declare, sorry, excuse me. I'm sorry. Now, so during this time, if you can look at the last statement on the screen, the president declares the powers of the legislature of the state shall be exercisable by or under the authority of the parliament. Okay, so this is one. Now, very, very important one. Once the president's rule is declared, as we know, it has to be ratified by the parliament within a period of 2 months. It should be ratified by the parliament with a simple majority within 2 months. So then it will continue for 6 more months from that particular period. Now the point is that, can we challenge the imposition of the president's rule after it is ratified by the parliament? Immediately after the declaration, yes, we have understood now because the intentions may be malified. Number two, after it is ratified by the parliament, can you challenge it? Answer is yes. The Supreme Court made it very, very clear that you can challenge it. This is because when the imposition itself was done in a wrongful manner, what is the validity of the ratification by the parliament? Hope you are getting me. This is the opinion of the highest judiciary in the country. Is there any logic in this? Absolutely, there is a logic. Imagine a situation. Imagine, that's right. Imagine a situation. If Supreme Court allows quashing the president's rule and reinstates Harish Rawat the government in Uttarakhand, example, imagine a situation. Maybe 29th or some other day may be fixed by the judiciary. During that time, imagine a situation. If Harish Rawat fails to prove his majority, then what will happen? Then what will happen? Again, that will become a constitutional crisis. We are not very sure whether the BJP will be in a position to prove its majority because of the support from the MLAs, other MLAs who have defected from the Congress party. So they have been disqualified. That's a different issue now. That is the reason why it is not just one, two, three. There are so many issues that are coming into the picture with respect to the so-called this one, President's rule in Uttarakhand. Hence, I want you to very, very seriously follow what exactly is happening this. So as far as this Uttarakhand case is concerned, April 27th is going to be so crucial. And what the Supreme Court is going to say, so we have to wait and watch. But otherwise, let me open the document once again and show you some more points. It is Article 74. It is saying like this. There shall be a council of ministers with the prime minister at the head to aid and advise the president, who shall, in the exercise of his functions, act in accordance with such advice, provided that the president may require the council of ministers to reconsider such advice. Meaning is simple. Directly, the president need not accept the advice given by the council of ministers, but he has every right to ask the council to reconsider its advice, either it is generally or otherwise. Later, the president shall act in accordance with the advice tendered after such reconsideration. Meaning is simple. If the president is accepting for the first time, it's okay. If you are not accepting for the first time, second time, the president must accept it. This is what the constitution is saying. That is the reason why we say in India, the president is considered to be de jure head. Constitutionally, he is the head. There is no doubt. Right? But when it comes to the real powers, they are vested in the Council of Ministers headed by the Prime Minister. Look at this next article I have given for you. Article 361. I told you, no, this article is giving protection to the so-called the President of India and also the Governor of a state. Is that okay? So these two things you can see later. So, but what I would like to show you is that, right, the Supreme Court laid down certain guidelines so as to prevent the misuse of the Article 356 of the Constitution. Now let me tell you these points. Whatever I am talking to you, that is with respect to the so-called Article 356. It is the directions that are given by the Supreme Court in the year 1994. And this is the case which is very popularly known as S.R. Bommai versus Union of India. So during 1980s, so I am talking about, in Karnataka, government was established by Janata Party under the leadership of S.R. Bommai. Over a period of time, what happened? There was a party called Lok Dal, and that Lok Dal, it merged with Janata Party, and it has been renamed as Janata Dal. Janata Party, Lok Dal merged, and it became Janata Dal. So during that time, the cabinet expansion was done because you need to accommodate the new uh, members from some other political party. But immediately after that, what happened? Some people who are there in the government went to the governor and said that they are withdrawing the support to the chief ministers. Immediately after that, the governor has intimated the central government that because some of the members have withdrawn the support to the government has no majority. Hence, this is a situation where there is a demand for the declaration of the president's rule. This is what happened during that time. And immediately after that, it was accepted by the central government and the president's rule has been declared. Immediately after that, it has been questioned in the judiciary. The Karnataka High Court struck down this particular case. We are not interested to take it. Immediately, the case went to the Supreme Court. Later, in some other states also, like Madhya Pradesh, Himachal Pradesh, Rajasthan, in various states, these type of things happened. That's the reason why collectively all the cases were taken by the Supreme Court. And finally, Supreme Court has given the guidelines in the year 1994. During that time, Supreme Court was criticized because there was so much of delay as far as the guidelines are concerned. Hopefully, you are following all the points nicely. Listen to me very carefully. Later, in 1994, Supreme Court has given clear directions saying that when the so-called the president's rule can be declared. Okay, I am talking to you with respect to the guidelines that are given by the Supreme Court in popularly known case called S.R. Bommai case. Now, I am showing that to you. Please have a look at it. The majority enjoyed by the Council of Ministers shall be tested on the floor of the House. Meaning, you have to test them, ask them to prove the majority in the assembly floor of the House. Central government should give a warning to the state and a time period of 1 week to reply. If something is going wrong, meaning it's simple, central government came to know, example I'm telling you, if it comes to know that something is going wrong in the state and there may be a failure of the constitutional machinery, then you give a warning. We got the information there is a constitutional machinery failure and give reply within how many days? 1 week. That's it. Only after 1 week you have to take action and not before that. Right? The Supreme Court has said. Okay, that's number 2. Next, once again I'm opening the document. Please have a look at this. The court cannot question the advice that is tendered by the Council of Ministers headed by the Prime Minister to the President. But the court can question the material behind the satisfaction of the President of India. President of India, you are satisfied, but based on what material you have satisfied, that can be questioned by the court. Hence, judicial review will involve 3 questions. Is there any material behind the proclamation? Is the material relevant? Was there any malified use of the powers? These are the questions. If there is a proper use of Article 356, then the court will provide the remedy. Is it okay? Very, very important one. If there is improper use, what do you mean by this? If the court is satisfied that there is a malified intention, something is went wrong improperly, then the court will provide a remedy. Under Article 356, Clause 3, there is a limitation on the powers of the president. Hence, the president shall not take any irreversible action until the proclamation is approved by the parliament. That is, he shall not dissolve the assembly. What is the meaning of this? I told you already during the Indian polity classes. Once there is a president's rule in any state, either the state legislature can be dissolved or it can be kept under suspended animation. Now imagine a situation, president's rule has been declared and immediately after that the president has dissolved the assembly. It is irreversible again. Once you dissolve the assembly, you have to go for the elections within 6 months. Hope you are getting. That is the reason why court made it very, very clear. The moment you declare the president's rule, don't immediately go for the dissolution of the assembly, but otherwise kept this under suspended animation, because you need to take the approval from the parliament within 2 months. After that, if you want to dissolve, you may, but not immediately. So these are all the guidelines that are given by the Supreme Court in SR Bommai case. Article 356 is justified only when there is a breakdown of the constitutional machinery and not administrative machinery. If administrative machinery fails, you cannot impose the president's rule. If there is a failure of the constitutional machinery, then only you can declare the so-called the president's. Look at this. Whether courts can invalidate the president's rule? Yes. The Supreme Court held that the power of the court to restore the government to office in case it finds a proclamation to be unconstitutional, in court's opinion, is beyond the questions. Even in the case of proclamation is approved by the parliament, it would be open to the court to restore the state government to its office in case it strikes down the proclamation as unconstitutional. What do you mean by this? Just now I have explained you already. Once president's rule is declared, the court made it very, very clear that is subjected to judicial review. That's it. If the court finds that something went improperly, then the court can restore the government, suspended government. If it is already passed by the parliament, even then it is subjected to the judicial review. These are all the guidelines that are given by the SR, by the Supreme Court in the SR Bommai case. Even after that, even today also we are facing this problem. And again, once again, so this controversial topic has reached the apex court, right? We were feeling very happy yesterday because Uttarakhand High Court almost re-established the democracy in Uttarakhand. But unfortunately, because of the various reasons, the Supreme Court has issued the stay order on the order that is issued by the High Court. So we have to wait for April 27th, and we have to again wait for the Supreme Court to pronounce something, and probably that will put an end to the dilemma, confusion, or chaos in the so-called assassination of the democracy in Uttarakhand. We are not saying again I'm repeating, please. We are not saying that president's rule cannot be imposed. President's rule is very much permitted by the constitution, but the procedures what you are following, that is also very, very important. You need to know very clearly whether it is a failure of the constitutional machinery or it is a failure of the administrative machinery. If it is a failure of the constitutional machinery, yes, you have the right to impose, otherwise not. Is it clear? Let's wait for 27. Probably it would be very clear for us with respect to the court, what new directions the court is going to give. Again, I'm telling you, please, just because imagine a situation, the court may restore Harish Rawat government. I'm not saying that Harish Rawat government will continue for a long period. No, he has to undergo floor test. If he wins the floor test, if he gets the majority, then only he will continue as a chief minister. Otherwise, he has to step down. Otherwise, he has to step down. That is the reason why this is a number game magic, the magical figure. Simple majority is the magical figure. So we have to wait whether it is going to happen or not. What exactly is going to happen? We have to wait and watch. And I thank you one and all for being with me this wonderful evening. And I wish you all the very, very best. Take very good care of yourself and see you in the next class. Thank you so much.